I want to encourage everybody to come in and get the road on the show for the last session. Could everybody be seated? I'd like everybody to come in and be seated so we can get the last session underway.
Yeah, you put it closer?
Yeah.
Okay. It's on.
It's on. Should I?
Yeah, let me just put it on this part so I can at least float over you.
Should I try again?
Yeah, try it.
Okay. I'd like everybody to find their seats so we can get the last session on the road.
I'll take care of it. I can hear you, bro. Thank you.
Okay. I'd like to welcome everybody. I'd like to welcome everybody to this final session of this historic conference. I'm Rebecca Cook, a professor of law at the University of Toronto and co-director of the International Program on Reproductive and Sexual Health Law. This session addresses whether abortion in the U.S. should be resolved through the legislative actions or through the U.S. Supreme Court. The U.S. is one of the few countries, along with Colombia and Canada, that has tried to settle its abortion policy through the Supreme Court. There are other countries, such as, and most recently, Mexico and Portugal, that have addressed the issue first through the legislature, and then that legislation has been challenged in their respective constitutional or Supreme Courts. This panel will address whether it is sound public policy to rely on the legislatures or the courts to, quote, settle the abortion issue, or whether it is a matter of ongoing dialogue between the legislatures and the courts to address different aspects of the abortion question over time. Put differently, what is the proper role of the courts and the legislature in addressing this issue in the U.S. context? We have a distinguished panel who are known for their knowledge on this question, or various aspects of this question, and who are also known in the spirit of this conference for their ability to engage in respectful debate. The order of the conference is the order in which people are seated. First, Richard Garnett from the University of Notre Dame, then Robin West from Georgetown University Law Center, Don Johnson from Indiana University Law School, Peter Singer, one of our co-organizers of Princeton, and finally, Francis Kissling of the Center for Bioethics at the University of Pennsylvania. My role as moderator is to facilitate a fair, balanced, and enlightened debate. As with previous panels, each panelist will speak for 10 minutes. Then the panelists will be asked to pose one question of each other. Then it will be open to audience for their participation. We will conclude with each panelist making a final point in the order which they have spoken. So without any further ado, I'll ask Richard to take the podium.
Thank you. I want to begin by thanking whoever is responsible for these very interesting chairs we're sitting in. Like Proust's cookie, they take me back to my childhood. In my case, sitting in front of the television, watching the Jetsons, and Now, more seriously, I'm grateful to those who organized this conference for including me, and also I want to thank them for their aspirations and their commitments. I think we all agree that we need in our public debates, and I think particularly in the academy where a lot of us are from, more genuine engagement more respected and candid disagreements. And it would be great if this conference could be a start. So I'm a lawyer, and this means that I like to take straightforward questions, such as the one presented to this panel, and repackage them, complicate them, subdivide them, and sometimes avoid them. I can't help it. It's what I do. Every now and again, though, this question parsing habit can clarify things, and I hope that'll happen today. So I want to start with a few thoughts about what we mean when we ask whether abortion should be a constitutional question. Now, written constitutions, like that of our country, like that of our various states, they're laws, but they're laws of a special kind. They're basic foundational framework laws. They're the mechanism by which a political community forms or constitutes the governing structures through which they act. And in a constitutional democracy like ours, they're the means by which we empower governments to pursue and protect the common good. Constitutions identify, allocate, and limit the powers that governments have, that we, the people, give them. So our national government has, because we gave it to them, among other things, the power to regulate commerce and to coin money, and one of my favorites, to establish post roads. It does not have, among other things, the power to enact bills of attainder or grant titles of nobility or make laws respecting an establishment of religion. Our state governments have the powers given to them in their constitutions, which include the traditional police power to regulate generally in matters of health and safety and welfare. But they do not have the powers denied to them by their constitutions or by the Constitution of the United States. So they can't grant letters of marque and reprisal. Don't you wish you could have one of those? They cannot deny to any person within their jurisdiction the equal protection of the laws. So a constitutional question is a question about the government's power or authorization to act. It's about whether the power to act exists, and if so, where it exists. It is about whether the government may or even can act, and not so much about whether, all things considered, it should. Now, a political question, on the other hand, is a question about whether the government, or whether we, the political community acting through our government, should act, and how, and when. The constitutional question, then, is who gets to decide, or how should we go about deciding? With political questions, we ask, what, if anything, should we do? It's not then that constitutional questions are more important or difficult than political questions. It's just that, in a sense, they come first. That is, those of us who live under and act through written constitutions, we need to decide whether we may act before turning to the often just as challenging question whether we should. So in a real sense, constitutions make politics possible. A good constitution will facilitate a healthy, stable politics, in part by setting up good processes and structures, and also by removing certain questions, not all, but some, from the rough and tumble of regular politics. So, should abortion in America be a constitutional question? Part of the answer, I think, is yes, of course, it has to be. That is, the question whether our state and federal governments have the power to regulate, promote, facilitate, or discourage abortion is a constitutional question, because it's necessarily a question about the existence and the content and the limits of the powers that we've given our governments. The constitutional question, as I see it, is whether the specific regulatory powers given to the national government, or the general police powers traditionally associated with state governments, include the power to deal with abortion, and if so, subject to what limits. Now again, remember, a political question is whether, how, or why a power that exists should be exercised. It's about how to go about promoting the common good and securing the blessings of liberty and all those good things you remember from Schoolhouse Rock when they sung the preamble to the Constitution. The answers we give to constitutional questions are what make it possible or not to ask and answer political questions. So as my colleague Kathy Caveney discussed this morning, these political questions will include questions about the efficacy of law in solving certain problems, or questions about the extent to which law should, in a pluralistic society, reflect and implement the moral values of the majority. But when we constitutionalize a question, in a sense we remove it or take it out of politics. We take that question to some extent out of the arena of dialogue and conversation and compromise. This is what a constitution does. It identifies, allocates, and limits a government's power. It sets the agenda, or limits the agenda for politics. Well, now in my view, the Supreme Court has, to an extent, incorrectly answered the constitutional question with respect to abortion. That is, I believe the court has created and imposed greater limits on the powers of our government to regulate abortion than the federal Constitution actually imposes. So I think the court has mistakenly reduced or shrunk the realm of politics. It's taken away from us, I think, the power and the right to struggle with many political questions about abortion. So I disagree with the claim that you heard this morning that the court's Roe and Doe decisions are like the rulings in say, Brown or Loving versus Virginia. Those latter cases are moral achievements, and they're correct. The former, though, are not, in my view. And just to be clear, my view here does not reflect a secret desire to outlaw contraception or to regulate sexual activity between consenting adults. I think suggestions to the contrary, with all due respect, are unworthy. Now, our Constitution does limit the power of government to do things that the majority might think are wise and even necessary. That's a good thing. Questions like, should we impose cruel and unusual punishments? Or should the president suspend the writ of habeas corpus? These are not, I don't think, political questions because the Constitution doesn't permit them to be. But with respect to abortion, though, again, I think the court has mistakenly interpreted the Constitution and in so doing has excessively limited our power to deal with abortion politically. And this is regrettable for at least two reasons. Most important, I think the court's errors have made it more difficult for us to do what I believe political communities should do, which is to respect the equal dignity of every human person and to protect the weak and vulnerable among us. In addition, though, these mistakes by the court, I think, have badly wounded our political community and our discourse by declaring to be out of bounds or constitutionally illegitimate the values and commitments of many, or perhaps even most of its members. It's one thing to lose or to compromise in politics. Everybody loses sometimes in politics. But we hope everybody sometimes has the chance to win and to persuade others and to change hearts and to move minds. And with respect to abortion, though, the court has, to a great extent, told the many Americans who are pro-life that they have to lose, not because they didn't make their case, but because the Constitution's values are not their values. Now again, when I refer to the Supreme Court's mistakes, I'm referring to the fact that the court, I think, has misinterpreted the limits that the Constitution imposes on the regulatory powers of the governments to regulate and discourage abortion. So the court was wrong, I think, when it invalidated on privacy grounds the abortion laws of nearly every state, and when it constitutionalized a requirement that even after viability, abortions must be permitted for health reasons broadly understood. Now, the 14th Amendment does, of course, forbid governments from depriving anyone of liberty without due process or denying the equal protection of the laws. And unlike some lawyers who are pro-life, I believe the 14th Amendment actually entrenches and protects certain unenumerated rights, like the right to marry, the right to educate one's own children, and even to enjoy a certain sphere of privacy. These limits on the government's power are real and important, and they matter. We should cherish them. We should be scrupulous about observing them. At the same time, we should also care about political questions and about our right as members of our political communities to deal with them as best we can. And so I believe the government has misunderstood and misapplied the relevant limits, correctly understood the Constitution allows us to do more than the court's decisions do. In my view, laws regulating and discouraging abortion do not necessarily unconstitutionally burden women's liberty or deny them the equal protection of the laws. Now, I've been talking so far, as we usually do, about the limits that the Constitution imposes on abortion regulations. There's another way, though, in which the Constitution might be thought to answer the abortion question and to remove it from the menu of ordinary politics. The Constitution, remember, protects the life and liberty of persons. It requires that the government respect and accord equal protection of the laws to all persons. So certainly it would be unconstitutional for the government to select one category of persons and exclude them from the laws otherwise applicable protections against violence. One might think that our laws allowing elective abortion do just that. That is, they exclude a particular vulnerable group of persons and place them outside the law's protections. They fail to protect them, and so they protect them unequally. Thank you.
Good afternoon. So, long day. Many thanks for including me. Many thanks in particular to both John Finnis and to Peter Singer and several others here for their extraordinary work in ethics and in legal philosophy both, which over several decades now I've learned from, been inspired and provoked by for many years. That work has been formative for me. So I'll start with my priors. I believe that the decision to have an abortion is often morally wrong. I also believe that states should not, as a matter of political morality, criminalize abortion. And third, I believe that the question whether or not a state should criminalize abortion, although a deep one, and even, in a sense, a constitutional one, should not be resolved as a matter of constitutional law. That is, I do not think that there should be a constitutional right to an abortion in the way that phrase is typically used. I won't dwell on the first part of this, my belief that abortion is often but not always immoral, other than to note that I agree with much of what David Gushee said yesterday morning, particularly his kind of moral canary in the mine point. A culture in which a quarter of pregnancies end in abortion is a sign that something's deeply wrong with our families, our sexual ethics, and our communities. I'll say a little about the second and third points, though, and then I'll focus most of my time on the last. So why shouldn't states criminalize abortion? This is very much a matter of how we constitute ourselves in a polity. So it is a constitutional in a direct, but not in a legal sense. One problem, among others, with the criminalization of abortion is an equality concern, but not equality as meant by 14th Amendment law. So contrast these two legal states of affairs. On the one hand, we share, as a polity, the quite firm conviction that's widely reflected in our law that an individual's physical body is inviolate. As mentioned yesterday, we don't require the parent of a born child to give, without their consent, even a fingernail to save the life of their born child, even if that child was consensually and lovingly conceived and is here in the world solely because of the parent's loving intercourse. As Eileen McDonough has noted, were that child for some reason to try to force the parent to hand over the fingernail, not only would the parent have a right to defend himself against that non-consensual taking, the state would be and would often feel obligated to assist him in resisting that forced taking. Why? Why don't parents have a legal obligation to do what they clearly have a moral obligation to do? Well, basically because of a deep, widely held, indeed constitutionalized conviction that people own their own bodies, and so we just don't do that to people. We don't require people to give their bodies or their body parts over either to the state or for the use of others, particularly now that we've ended the draft. So, there are constitutional limits on the power of police to invade the bodies of suspects, of interrogators to do so. We recoil at torture partly for this reason, and on and on and on and on. Okay, now on the other hand, contrast that general claim about how we Americans just don't allow non-consensual invasions of people's bodies because it violates human dignity and so on, with the legal status of married women's bodies as of around 1970. In 1970, many states criminalized abortion, but they made exceptions for pregnancies caused by rape. Those same states, though, typically had marital rape exemptions worked into their definitions of rape. Put those two halves together, something which no one has satisfactorily done, in my opinion, to get a full understanding of the legal status of married women's bodies until about 1980, and here's what you get. Married women's bodies could be penetrated without the woman's consent for her husband's sexual satisfaction, regardless of her will, consent, or desire, and then her body could be impregnated without her consent, contrary to her will and desire. She would then be required to carry the pregnancy to term without her consent against her will and regardless of her desire, and then she would, by virtue of social convention, be expected to mother without her consent, contrary to her will and desire, for most of her adult life. So, this idea that we just don't do this to citizens' bodies since the 13th Amendment, that it violates human dignity and so on, as of 1970, was subject to this rather large and virtually never explicitly stated exception. We do it, in fact, or we did it all the time, routinely, without question, so commonly, so ordinarily, it was background noise to married women for most of their adult lives. This, I think, profoundly affected women's sense of self, whether or not you're married, of political agency, capacities in the market, liberty and equality, ability to be the sort of self-regarding, utility-maximizing, agentic, active, sovereign consumers and political beings so expected and valorized in liberal society. And of course, it affected the way women were and still are somewhat viewed, thus the continuing problem of coerced C-sections and so on. So the end of the marital rape exemptions in the 80s and the decriminalization of abortion in the 70s were, in my view, moral imperatives that had everything in the world to do with how we constitute ourselves as a polity and how the state performs and should perform as a moral actor. It is not clear to me, however, that this should be a matter of constitutional law, that states not have the power to do this thing that, in my view, they should not do, okay, this thing being criminalize abortion. There are at least 4 costs of doing so, 4 costs of Roe v. Wade, in other words, that I just want to list. First, the choice, privacy, liberty rhetoric of the right to abortion as construed by Roe and Casey further privatize pregnancy and parenting both, and therefore legitimate the privatization of whatever costs accompany pregnancy and parenting. If a woman can choose not to carry a pregnancy to term, then when she does carry it to term, she has in effect consented to the costs of that choice, including the skyrocketing costs of childcare, education, and health care for that child, just as if she consented to the purchase of an expensive car, she's consented to the costs of its upkeep. We have, in effect, in other words, made mothering a choice when we make abortion a choice, and in the context of a liberal legal system's valorization of choice, to the degree that we have done that, we've made it harder rather than easier for us to argue for greater public support for poor parents. She chose it, that being motherhood, she's stuck with it. To think otherwise would be impermissibly paternalistic. Second cost. Supreme Court decisions are subject to reinterpretation. Roe, Casey, and so forth can be and will be interpreted in light of cases that come after it. So, the Roe case that David Garrow loves yesterday, or has expressed his love for, right, establishes a privacy and a liberty right that frees human beings in all sorts of laudatory ways. But that's not the only possible interpretation of Roe v. Wade. Roe might come to be viewed someday, soon, as one of a series of cases establishing essentially a defensive right that is granted to individuals to avoid the ill effects of a sub-minimal state. We don't have a right to health care or child care, but we do have a right to an abortion, a right to take an action such that we will not need health care or child care. We don't have a right, the Supreme Court has recently opined, to police protection against private violence, but we do have a right to a gun, the court has recently held, so as to better resort to self-help. We don't have a right to palliative end-of-life care. Maybe, therefore, we should have a right to die. These are, in my view, dystopian rights. They're all rights to kill, a right to kill a fetus, a self, an intruder. They all can be viewed as necessitated by, and therefore justified by, the need to live decently in a sub-minimal state that has failed in its essential purposes. The need to live in a state, in other words, that has failed to provide a community that shares the cost of health and education of new life, a state that fails to provide a police force to protect against private violence, a state that fails to provide care at the end of life to protect against pain. These rights that I call defensive rights, to abort, to die, to a gun, now perhaps to not buy health insurance, as those become entrenched, the idea that the state has no obligation to provide what ought to be regarded as essential state functions, support for poor parents, support for palliative care, guarantee of some measure of safety and health care, will diminish. We have these rights in part to protect us against the malfeasance of a state that no longer has an obligation or duty to provide what ought to be regarded as essential services. Third, constitutional rights invariably degrade politics and demean democracy. Sometimes that's worth it, sometimes it's not. Peter Singer's going to talk about it, so I'll skip it. Now, last, I want to close by noting that constitutionalizing abortion in particular obscures common ground, the goal of this conference, in 2 ways. First, it tends to obfuscate areas of shared values. In particular, it tends to deny the needs of, because it denies the reality of, girls and women who carry unintentional and unwanted pregnancies to term for moral reasons regarding the human status of the fetus. David's comments today were a case in point, as were, I think, Peter Singer's yesterday. I have many, many students who are against the criminalization of abortion, who are pro-sex, pro-birth control, and morally opposed to most or many or even all abortions because of their belief in or their commitment regarding the moral status of fetal life. That's a perfectly coherent argument shared by many. It's no longer an unusual position within the pro-life and pro-choice community. And then second and last, it obfuscates common ground projects. Many have been noted through the conference, most importantly the common goal of minimizing abortion by addressing the poverty that motivates most decisions to abort. But there are other ways to minimize that haven't been touched on. We could bring down the number of abortions simply by imposing a sharing regime for the costs of unintended accidental pregnancies between the partners. An unintended accidental pregnancy is both accidental and unintended. We could share the costs of unintentional accidents in this area, as we do in other areas, share it between the tortfeasors. The woman should not bear 100% of the costs of pregnancies that are not directly related to childbirth and parenting, as she does now. Second, we could initiate a pro-contraception campaign that emphasizes the moral duty to use birth control, not only the right to use birth control. Finally, we could endorse a pro-sex campaign that emphasizes a moral duty not to have unwanted sex. Unwanted consensual sex is not rape, but it's harmful. It has costs for girls' and women's integrity, agency, and adult capabilities. A girl or woman who does not want sex has a moral obligation to her future self not to consent to it, and the boy or man has an obligation not to have sex with a woman who doesn't want it. I don't hope for Roe's reversal. I agree with Dorothy Roberts and others that doing so would do little but increase the number of deaths caused by illegal abortion. I think we need to be frank about the costs of this decision to poor women and children and to our politics. Those costs are substantial. We need to recognize them forthrightly and address them. One way to do so is through civil, open, fair political dialogue between people with differing moral views, aimed at locating sensible compromises and policies we can all live with under one roof. That's what we're doing here. I look forward to the day when these words appear, open hearts, open minds, fair-minded words, are regarded not as the extraordinary moral ambition of an historic conference, but rather as the profoundly commonplace presupposition of utterly ordinary politics on this subject and all others. Thank you.
I want to thank Francis and Peter and all the organizers for bringing us together from a variety of perspectives. I'm very glad to have been included. I cannot resist noting that on this panel, I am the conservative. By that, I mean I support the Supreme Court's nearly half a century of rulings upholding the right of an individual to make his or her own decision about childbearing. And under our Constitution, fundamental liberties simply are not left to the whims of democratically elected legislatures. I'm just going to summarize very briefly. I believe the court was very right in Griswold to strike down a Connecticut law that made it illegal for even a married couple to use contraception. The court was right to strike down a Texas law that sent doctors to prison for performing an abortion under almost any circumstance. The court also was right to adhere to stare decisis. That means even if a president's new appointments to the court, new justices disagree with Griswold in Roe, that simple disagreement does not justify overruling those decisions today. I realize many of you here today agree with me, and many here today do not agree with me. In the conference's spirit, I am not going to try to persuade anyone on the merits of those views. Instead, what I would like to do is, Professor Garnett, I think, helped set the stage for this. I want to continue to look at the court's doctrine on these issues and see what it teaches us at least give it a shot, about possible grounds for agreement and common ground and shared values, whatever your favorite phrase is. Because I think that though we disagree on the bottom lines of those decisions in this room and in this country, a better understanding of the doctrine, the court's reasoning, I believe it just might help us make some progress toward shared goals of healthy childbearing, pregnancy prevention, and reproductive health and justice. Some, including Robin, have expressed concern that the doctrine may somehow stand as an obstacle to achieving these goals, and I just would say I just don't see it. I strongly disagree. Many of the advocates with whom I worked for many years to uphold Roe have dedicated their lives to the broadest definition of reproductive justice, issues from poverty, sexual violence, maternal and child health, to prevention of unintended pregnancy, and safe and legal abortion. Griswold and Roe did nothing to remove these issues from the democratic arenas. What the court did was take off the table one approach to some of these issues, and that is the government's use of the force of law to dictate for all what should be, in my view, a personal decision informed by each individual's own family and health considerations and religious and moral views. So legislatures, as we all know, have continued to enact hundreds and hundreds of abortion restrictions. More to the point, for what I'd like to do today, though, the court's rulings obviously leave open, wide open, many means of promoting reproductive health and justice, including by reducing the number of abortions. I would argue that even more than that, and this is my essential point, I believe that the constitutional doctrine can be read as actually inviting a broad range of policies that women and men would be supported by in their desire to have healthy families at a time of their choosing. So, in other words, I would say that the import of the Supreme Court's doctrine is that in our constitutional system, the government's role is to support women's health and decision-making. It is not to make life-altering decisions for them, and there's no inconsistency in the two parts of that. So now look at the doctrine. So we've all heard Griswold and Roe attacked for inventing the right to privacy, a word that the Constitution does not use. The Constitution does speak of liberty. By its express terms, the Constitution protects liberty. That's where the Supreme Court has located the protection at issue in these cases. I want to be clear that there is no real disagreement among Supreme Court justices that if the government tells people they may not use contraception or abortion, liberty in the constitutional sense is at stake. Now, what is disputed, sharply disputed, is how democratic majorities should be able to interfere with that liberty. The flip side of that is, how should a court scrutinize a law that interferes with liberty? Now here, I'm going to get a little technical, so please bear with me. The Supreme Court's usual answer to that question is, it depends. And the court applies typically a two-stage analysis. Stage one, the court will ask, is the liberty at stake an ordinary mere liberty and trust, or is it so important as to constitute a fundamental liberty? Then at stage two, the court will examine the government's reason for the restriction. And here the type of liberty matters. For an ordinary liberty, the court will almost always side with the government. In deference to the democratic process, it will uphold the restriction. But where the law affects a fundamental liberty, the court will take a hard look at the law. It will ask two questions at the next stage, stage two. One, does the court have a very strong, compelling reason to support the restriction? And two, are there alternative means of promoting the interests that are less restrictive of liberty? Now, the court in recent years has muddied the doctrine as applied to abortion, but that is essentially how the court typically applies the analysis to an alleged restriction on liberty. Okay, so how might understanding this doctrine help? I believe it can help identify where we agree and where we do not. I would suggest that we seek consensus at stage 1, that abortion restrictions inflict very real harm to women's fundamental liberty, and acknowledge that our real differences arise at stage 2. So at stage 1, the nature of the fundamental liberty, that's identical whether you're talking about Griswold or Roe. It's the right to decide whether and when to have children, considering one's own family, health, life circumstances, according to one's own conscience. So just consider, without the ability to control reproduction, an average woman could bear 10 or more children over the course of her lifetime. American women, of course, have an average of 2 children. So for women, the vast majority of whom marry men, sex for purposes other than procreation is a fact of life. Consensus on stage 1, of course, would not end the debate. We still have stage 2, the government's interest in embryonic and fetal life. Is this interest compelling? We're clearly not going to reach consensus in this room on that question, but I do see the potential on the second related question, and that is the government able to promote its interest through alternative means that are consistent with liberty? And I would add consistent with women's equality. And the answer there is clear. The government does have less intrusive options available to reduce abortion. You know, outlawing abortion is maximally harmful to liberty and to women's equality. It's also not very effective. Witness the millions and millions of women who broke the law and risked their lives and health to control their reproduction prior to Roe versus Wade. Constitutional doctrine also tells us that we must consider the impact on every woman, not just the average effect. So common ground cannot mean compromise restrictions that those with enough money and connections can circumvent, but heap harm on the poorest and most vulnerable women, which was the effect of criminal laws pre-Roe and many restrictions today. And I just want to tell you one statistic from the time before Roe, and this is a great book I would recommend, Before Roe versus Wade by Reva Siegel and Linda Greenhouse. And this is a compilation of documents pre-Roe, and they include this fact. Between 1951 and 1962, over 92% of women who received hospital abortions in New York City were white, while over 3/4 of those who died from illegal abortions in the city were women of color. So I realize many who want to overrule Roe will resist describing the liberty at stake as fundamental and agree to just talk about the stage 2 of the doctrine. And it does make their argument more difficult, but if we're serious about making progress, as I think we should be, and I'm very happy to be part of this project, we have to move beyond what scores points, and we have to move to what is fair and true. And I'd respectfully ask that we should be accurate and fair in describing the burdens of restrictive laws. We should not misrepresent effects of laws, nor should we exaggerate the failure rates or potential side effects of contraception or abortion. We should not hold up anecdotal experiences of some women as universal. We should not disguise onerous restrictions on health clinics, such as trap laws, as promoting health when they're really attempts to shut down clinics. So those are just a few examples where I think we can agree on the facts and then move on to the solutions. To conclude, I think one key step in moving forward is agreeing that fundamental liberty for women is at stake. And then we see that our Constitution clearly prefers the range of policies that in fact do reduce abortion through means that help women and their families avoid unintended pregnancy and choose healthy childbearing. Thank you.
Thank you. So let me state my positions, where I start from. I think you've heard me already. You probably know that I think that the overwhelming majority of abortions, at least, are not morally wrong. I also think that abortion should never be a criminal offence. At the same time, I think that abortion should not be a constitutional matter. I believe it should be left to the legislatures. So to that extent, I agree with Rick Garnett. We have common ground across views about abortion on this issue. Why do I think that? I think it as a point of political philosophy. It's because I'm a Democrat. I think that political decisions should be made by the citizens voting in a political system that gives equal weight to every vote. I don't really want to comment on the specifics of the United States Constitution. I'm not a constitutional lawyer. There are certainly people on this panel much better qualified than I am to do that. I'm making a general point about what I consider to be a desirable form of government. And let's therefore raise our gaze beyond the boundaries of the United States. There are many other democracies in the world, and many of them recognize the sovereignty of the legislature in a way that the sovereignty of the legislature is not recognized in the United States system. I happen to have lived for some years in two of those other democracies, Australia and the United Kingdom. In neither of those is there a constitutional right to abortion, and yet in both of them a woman's right to abortion is protected. It's better protected in those countries than it is in the United States. Better protected not least because every woman who wants an abortion can get one, and can get one paid for on the National Public Health Service. There's been no serious debate about that in either of those countries for many years now. In Australia, for example, we had 17 years of conservative federal government, one of the most conservative federal governments that we've had in my lifetime. It never proposed to reduce women's rights to abortion. It never proposed even to cut back on public funding of abortion. At one point, a Catholic federal minister of health suggested this and was quickly hosed down by his prime minister, the man who had appointed him, in other words, and could dismiss him with a stroke of a pen, because that was simply not going to be politically viable to attempt to withdraw funding from women seeking abortions. Now, I think therefore, and I really agree with Rick Garnett, that this is a political matter. I think that because I think that constitutions should be limited to procedures for the democratic majority to reach its decisions. So a constitution can reasonably insist on one person, one vote, and on those votes having equal power, and on the electorates not being gerrymandered to prevent citizens having equal power. It can also have at least some insistence on free speech so that politics can be debated. All of those procedural matters are reasonably and properly within a constitutional scope. But I don't believe that a constitution should get into substantive political matters that have nothing to do with the process of making decisions. I don't see why those matters should be taken away from the democracy. I don't see any reason to believe that courts will make better or wiser decisions than the majority. And to those who say, but there are fundamental rights that should be protected, I would say those rights are contested. Clearly the right to abortion is hotly contested, as we've seen here. And why should the resolution to that decision as to whether that right is one that belongs to the woman or one that is required to protect the life of the fetus, why should that be made by an unelected body of people appointed for life rather than by the majority in the normal political process? Now, admittedly, I have to consider the consequences of taking this view. And the immediate short-term consequences in the United States on the abortion issue, I think, would be very bad. They would mean that many women would not be able to get an abortion in their state And although I'm sure that some organizations would come into existence to provide free transport to states that have more liberal laws, it would still be difficult, maybe impossible, for many women to get abortions, and they would resort to illegal abortion, and we've heard all about the terrible consequences of that. It's a heavy price to pay, I agree. I also have to accept that there's a lot of other decisions for the Supreme Court that I would have to say should not have been made for that reason. I mean, take Griswold. Of course, it's absurd for a state to prohibit contraception, but I don't see that it's a constitutional matter at all. I can't believe that the state of Connecticut would be enforcing a law prohibiting conception today. In fact, it didn't really enforce it even in the days of Griswold. And any attempt to enforce it would have led to its rapid repeal, of course, or the legislature would have been completely changed. But there are other worse cases where that might not happen. The case in which the Texas's sodomy law was struck down, Lawrence versus Texas. I can't see that as a constitutional matter. I think, again, it's quite wrong for a state to prohibit sodomy or sexual relations between people of the same sex. I would readily join boycotts of any state that did that, and any other kinds of legitimate political pressure to prevent that happening. But I don't see it as a matter for the Constitutional Court really to decide on. So there would be prices to pay, but of course there would also be gains. At the moment we're seeing an electoral campaign in which spending is up dramatically. I heard, I think on NPR, up 75% against the 4 years ago comparable campaign, and that is mostly corporate spending favouring the Republican Party, which is the result of the fact that the Supreme Court in the Federal Electoral Commission versus Citizens United struck down a part of the campaign finance law. I think that's a disastrous decision, and although that could be said to be a part of free speech, I think that the legislature ought to have much greater weight on deciding the boundaries of free speech. It obviously should not be able to curtail free speech entirely, but I think whether corporations are entitled to buy as much airtime as they like for their political views is a matter that the legislature should decide, not the Supreme Court. David Garrow, who spoke strongly in favour of many Supreme Court decisions, also said that he was very strongly for gun control. Well, the Supreme Court is now making gun control difficult. There are costs and gains, I think, to this approach. But I also believe that taking the matter out of the hands of the electorate has had other undesirable, broader effects. If I put myself in the position of someone who is opposed to abortion, and we've had this discussion, I think we respect the views of those who have. We might think, as I do, that they're mistaken, but they're respectable, defensible views that belong in the political arena. I would be enraged. I would be enraged by the fact that even if I can get a clear majority of Congress people thinking the way that I do, whether in my state or federally, I cannot get change on that issue, and that I have to go through an almost impossible process of a constitutional amendment, really, to ensure that that would change, or rely on getting presidents appointed and judges retiring or dying in the right times, fairly arbitrary process. So the majority has been disempowered. And I think that has had a poisonous effect on the American political process. I think that has brought more energy to those who oppose this issue and brought them into politics not only on this issue but on many other issues where I think it's had a serious negative effect. And gay rights would be another example where I think bringing that kind of wave of feeling into politics has had a very serious negative effect. I believe that if we did have legislators sorting this out, and if they had done so since the 70s, we would have much less conservative laws in many states than people imagine, because had they perhaps initially prohibited abortion, I think they would have seen the consequences of that, and I think many of them would have at least modified those laws, if not withdrawn them altogether. Thank you.
What a task.
Well, first of all, I want to thank the organizers for inviting me to be on this panel. Really a great privilege. Second of all, I have an announcement to make, and that announcement is, if you have a date with me for dinner tonight, would you meet me at the Nassau Inn at 6:15? Okay, taking care of my business. And then let's go for it. I'm not a lawyer. Somebody once said, Frances, you should have been a lawyer. Okay, I've never had that said to me before. I am not a lawyer. Someone once said to me, Frances, you should have been a lawyer. And someone else said to me, Frances doesn't have to be a lawyer. She tells lawyers what to do. Okay. And I think, in a sense, that's what I would like to do today. I think that how I would approach this question to some extent is, in a certain way, I'm not as interested in the abstractions or some of the elements of principle that have been discussed here. It's not that I don't think they're important, but they're not what motivate me on this issue. What motivates me on this issue is an outcome and also a belief in what I consider to be human rights. And so what I would be doing after listening to a conversation like this and worrying about the implementation of the things that are important to me is sitting down with some lawyers who would agree to take my case, some of them might not, and saying, look, I don't care how you accomplish it. I don't care whether it's through a constitution. I don't care whether it's through the UN. I don't care whether it's through state laws. I don't care whether it's through federal laws. There are certain things that I consider, and others, to be fundamental, and I'm not using these words in legal sense because that may not be correct, basic human rights. And I also want this presentation to close this conference on the subject of women. And we opened this conference on the subject of fetuses, and I think it's now time to bring it home in terms of what our policies, our thoughts, and our ideas about who women are influence us and influence abortion policy. For me, in the modern construction, human rights are largely embodied rights. When I use the word embodied, it's not an abstract word. They're rights that pertain to my body and to your body. The right not to be tortured. Okay. Let's go into more modern rights, which some don't accept. The right to have food, the right to have shelter. Even the right to free speech is a body right. And for me, the bodies of women, historically and in the present moment, are not respected. The question of the moral status of women, particularly as relates to their bodies, is an open question. It may not be as big an open question in the United States as it may be in other places, but it is an open question. The prevalence of rape that goes unprosecuted and unpunished in our society, the fact that there are still people in the United States who can say and have support for questioning women's culpability in their own sexual assault is a sign that our bodies and our identities are not respected. The kinds of procedures you heard about today in pregnancy is another sign that women's bodies are not really respected. The stonings that go unremarked upon in our society that happen to women in other countries are another sign that women's bodies are not respected. Now, I could go on for 20 minutes and go through all of this, but I don't have 20 minutes, and I hope that I have made the point that there are deep ways in which women's bodies are violated every day and in so many ways. For me, abortion is not separable from these other body rights. For me, the idea that a woman could be forced to carry a pregnancy to term against her will is a violation of her body right, which is a violation of her human rights. I want laws at whatever level, whether it's in the UN documents, the US Supreme Court, the Colombian Constitution, the Taliban directives, the state of South Dakota. I don't care what level it is at. I want some visible symbols that our world accepts these rights of women. To that extent, the only thing I will say in defense of Roe, to that extent, I love Roe. There are many, love-hate relationship with everything in life, but so I have my hate relationship with Roe too. But to the extent in that core holding of Roe, there is a kernel of respect for the right of women to have autonomy and be respected in their bodies. I'm all for it. So that's the first part of what I have to say. Now, how much time do I have for the second and the third and the fourth part, and what I want those lawyers to do? So I want those lawyers to make that happen. I know that people disagree with me, and I don't care. I don't care. I believe these things are so important to how women will be seen in the future that other consequences, the consequences Peter articulates, the consequences that Robin articulates in particular, which I share and want to find other solutions to, I will not sacrifice the recognition of our right not to be forced to be pregnant, to have our identities changed in pregnancy, is not acceptable to me. Now, I want to make a few comments about a couple of things that have been said here. The effect of Roe, specific to the U.S., the effect of Roe on other needs and other wants that women have, on our ability to demand of the state those things that make women's lives better, enable them to have children, and to do so well, to do so in a way that is good for them and good for their children. I have a very pessimistic view of this. I think women have been treated like crap from time immemorial. I think before there was Roe, men were off the hook on pregnancy. The state did nothing for women. And I think those conditions largely continue to exist. I'm not convinced that Roe has contributed to this attitude in our society. That attitude is so much more deeply embedded in terms of the lack of women's worth, the naturalness of being mother, the concept of sacrifice and suffering that women should engage in. All of those things are so much more important in the fact that we don't take care of women than the very question of Roe or a private right to abortion. The other thing I really, I feel strange saying this, it'll be my concluding remark because the timekeeper says I have 1 minute. At this conference where we are trying to find what our shared values are, I think I have a much darker view on this than it would be perhaps appropriate for me to be more sunny about the fact that we can share certain values and move forward on this issue together. I actually see very little of that. I think that there's a certain amount of hype in the public process, and those of us who believe in finding shared values and try to talk about, well, we all worked together, we all can agree that women shouldn't be shackled in childbearing. And this is like a big deal. This should not be a big deal. Whether we work together or we work separately, nobody should be for women being shackled in pregnancy. We have not made progress if we both start working on that. And we have not made, and what I have seen in this conference, that we have profoundly different frames, moral frames, philosophical frames, from which we are approaching the issues of women and abortion. And in that context, I don't see Roe or the constitutional recognition as the barrier to our working together. And I don't think we're going to be really working together a lot in the future. We may be more civil with each other, we may be more respectful of each other, but we do not have a very strong convergence of core values.
Now I'd like to ask the panelists to propose questions of each other. With that statement of Francis's, Richard, over to you.
Just really quickly to take up Dawn's invitation, just as a thought experiment, let's assume that criminalization is sort of off the table and we're coming up with our ideal legal regime. What would you think of measures that were designed to try to convince women considering abortions to not have them? I mean, is it...
It would depend. I mean,
yes, help me...
religious entities do that all the time. It happens.
Sometimes governments try to encourage us not to... Sometimes governments do try to encourage us not to do things we have a right to do. Could this ever be an example, do you think?
It's very abstract. I think in civil society and in our religious and private lives, certainly happens all the time. I think, probably not the government, but I would have to, I don't know what in particular you're thinking about.
I'm thinking about
we do have already, we have waiting periods, for example, right? We have wide variety of types of laws at the state level where physicians have to read a script to women, and they say different things. Some have been invalidated, others upheld. The waiting period, though, the Supreme Court has upheld with certain script requirements. I think that's awful, the waiting period. I think part of our common ground effort should be to recognize that the vast majority of Americans believe, as do I, that a later abortion is more morally problematic than an earlier one. So we should get rid of these restrictions that keep pushing abortions later and later in pregnancy. So I think there's tremendous amount we need to do. I keep thinking about my own state of Indiana. Indiana, I'm really a New Yorker, but my husband's a Hoosier and I've been there for 12 years, so I can say, my state of Indiana, the legislature is just paralyzed by abortion restrictions that are attached as poison pills to a wide range of really positive common ground type legislation. And so, I share Francis's pessimism, but it also makes me think how essential it is we get beyond this. So we're one of 5 states that don't have a hate crime bill, because every time it's introduced, an abortion restriction is attached. In the last year or two, they tried to streamline adoption, so step-parents and grandparents can more easily adopt. A great thing. Anti-abortion, legislators, I shouldn't use that phrase, I'm sorry. Legislators, attached an abortion restriction onto that and killed it in these poison pills. And so I really do hope, Francis, that it's not as desperate as you describe, but I'm worried. But I do think the only way we can achieve, what I would focus on is positive options for women and families. The range of programs that will allow them to have children healthily when they're poor and lacking the resources and able to prevent pregnancy until they're ready and choose to have it. There's just so much we can do. Adoption. Our Planned Parenthood in Indiana includes adoption services and was working for the streamlined adoption bill. So the potential, I think, is just enormous. To do things that we can agree on before we get to trying to craft ways for the government to shame women out of choosing abortion, which is what I worry about if we're talking about a government program to discourage women from having abortions.
Peter, would you like to proceed with your question, and then maybe Robin and...
No, I didn't really have a question. I think, we've said different things in a way. I mean, to some extent, Rick and I have said the same thing, different perspectives. And the rest of us have said different things, not actually always addressing each other. I think, John, you were talking about the U.S. Constitution and how you see it. I wasn't specifically talking about that. Frances was really talking about the importance for her of the issue of protection of women, and that basically trumps the niceties of political philosophy that I might have talked about, or the constitutional issues that Rick might have thought about. So in a way, it doesn't give rise to me for a question. I'd rather hear what the audience says.
I'd like to ask a question.
Okay, then Frances, and then maybe Robin, and we'll open it up.
I actually want to find out how much Rick and Peter agree.
Okay.
Okay, so, and that's whether I'm a little suspicious. I have this suspicious side of my personality. Do you do believe that abortion should be illegal? Yeah. Am I wrong? I'd just like to know.
I mean, so the question presented to us, so yes, but the question presented to us is the question about should it be a constitutional question.
Right.
So I do believe, and here obviously Peter and I disagree on this point. I mean, I like to think respectfully, but still disagree.
Yeah.
I believe the unborn child I have the John Finnis view, and he has the Peter Singer view, as would be appropriate given the name. And that's going to have implications for how I act politically and how I vote, and the kind of policies that I think are justified and morally required. For me, it actually doesn't answer the question whether it's constitutionally permissible to regulate abortion or not. And I'm actually quite prepared, living in the real world, for the reality that in a world without Roe, in a world where the Constitution was interpreted, from my point of view, correctly, that abortions would be legal in every state up to a point, and there'd be restrictions kicking in at some point, and some states would have public funding and some wouldn't. I would vote against public funding, but friends in New York would vote for it. It's not perfect from my point of view, but I don't believe in letting the perfect be the enemy of the good.
If by some strange circumstance, Rick, the Supreme Court actually decided that there was a fundamental right of the fetus to life, we may think they've decided that wrong. You may even think they decided that wrongly. But let's say they did decide that, and that they said that the result of that, contrary to Roe, is that no state could permit abortion. Would you fight against that? Because constitutionally it's not the way things should happen?
Frances, I think I'm just not going to answer that question, because I do think the question presented to us is what the Constitution says about this question, and I don't think the Constitution, at the end of the day, I don't think the Constitution requires every state to ban abortion. So I think I'm comfortable sticking with the topic for this panel.
Okay.
Dawn, and then Robin?
Let's see, so I have a question for our organizers. And this is very respectful, and this is in the spirit of really hoping this continues, and it's kind of in the way of a suggestion. So I know you worked very hard to get the whole range of perspectives among the speakers, and had a broad range, but it seems to me that there are two important perspectives that are not present in the way I think they should be, and I'd like to see them added. And so quickly, and I'd like to know what you think about that, whether they are missing and whether you just can't include everything. But one is that religious faiths differ on this question. And I feel like, they differ. And most people, I know you know that, most people I don't think appreciate that. So I just want to point out my own United Methodist Church, to which I have been an active member my entire life, in 1972 adopted this position. We call all Christians to a searching and prayerful inquiry into the sorts of conditions that may warrant abortion. We support the removal of abortion from the criminal code, placing it instead under laws relating to other procedures of standard medical procedure. A decision concerning abortion should be made only after thorough and thoughtful consideration by the parties involved with medical and pastoral counsel. So I just feel like that impression, and I'd like to see a Methodist minister, that religious view from that perspective. The second perspective, I think, is not fully present, is the idea that you can believe abortion is wrong, but support Roe versus Wade. And so this panel was inspired by President Obama's Notre Dame speech, and today, all day I kept thinking about Mario Cuomo's 1984 Notre Dame speech. And so the iPhone's a great thing, and I was able to pull it up here. And, so this is just, I urge everybody to read this. It's just so thoughtful and eloquent about how, in his personal life as a Catholic, he respects the teachings of his church and in his own life, and he and Matilda, and it's, but as governor of New York, he supported going even beyond Roe, the Supreme Court rulings, to support state Medicaid funding for poor women. And what he writes here is, it's all about recognizing we live in a pluralistic community. And he writes, or he said at Notre Dame in 1984, when should I argue to make my religious value your morality, my rule of conduct your limitation? So I'd like you to get Mario Cuomo, next time to join our conversation. No, seriously, but that view, that is what Roe is all about. That, I respect everybody's views on what the moral status of the fetus is, and that's it. And embryonic and early human life, and that's all great. But question is, who decides? Going back to the old slogan, who's religious and moral and views are going to govern. And I want my, United Methodist views to be able to govern my decisions. So that's just like your reaction to whether, those two viewpoints really just didn't seem as present to me.
Yeah, I'll take your mic then. I think, is my mic working? Yeah, it is. Okay. Funny, it shows a red light, but anyway, never mind. Okay, so obviously, firstly, there's the limit to the number of perspectives we can get in, and I think one of the things was we believe that this debate is being carried out in this country in the political arena anyway, really in a way that accepts that we ought to be able to put arguments that everybody can respond to, irrespective of your religious views. That is, in other words, arguments that appeal to a broad notion of public reason, as philosophers sometimes call it. And if somebody puts a view from a religious position, well, I, for one, am not going to accept it. I mean, if that's the basis of it, I'm not a religious person, so I'm not going to accept the foundations or the doctrines that it's drawing on. So that's one problem. The other question, of course, is, well, why have a Methodist? If you're going to have a Methodist, you've got to have a Roman Catholic, and you've got to have someone of the Jewish faith, or someone of the Islamic faith, or Buddhist, or Hindus, or whatever. I mean, it's hard to know where you would stop there. And that would be a quite different kind of conference, I think. You could do it. I'm not saying that religious people should not come and discuss abortion. Of course, they can and are welcome to do so. But I think that's a different kind of question.
I would just add that I'm not quite sure on this subject, whether it's religion broadly or whether you were looking for something more or different in religion. There are on this program a fair number of Catholic theologians and ethicists.
Yeah,
now, they may well be not arguing as Catholics. It all sounded pretty Catholic to me. But indeed, that posture is certainly well represented here. Others on the organizing committee may disagree with me on this, but I think that there is a certain reality in looking at that which is broadly constructed pro-choice and that which is broadly constructed pro-life, that there is, within the religious community, there is a much larger contingent, I don't know if contingent is the right word, but I'll use it anyway, of to get pro-life people, and we talked about this a lot as a committee, a lot of the names that emerge are Catholic. They're not the only names, but there definitely is more dominance in the scholarly community where Catholics are concerned on the pro-life side. And we needed to have a lot of pro-life people.
Well, let me just say, though, because I'm sure someone like Charlie would want me to say this, that although we had a lot of Catholic theologians here, I didn't hear any of them arguing by appeal to what the Bible says or what the Pope says or anything like that.
Right.
Thank you.
Right.
I heard them trying to make arguments out of the natural law tradition, and maybe that's, what they're here for.
Let me
Robin, and then we'll open it up.
Okay. So, Fran, I don't have a question, I just have a response, and that is that the laws that you want, or the protections that you want for the liberty rights and the human rights that you care about, that I also care about, obviously, if laws that protect those liberty rights and those human rights that are enacted through a well-functioning democratic process will, by virtue of that fact, leave those rights far more secure than any anti-democratic Supreme Court case that hangs by one vote. I mean, that's just, if we still need that proven to us after our history with Brown and its backlash, and Roe and its backlash, and Lawrence and its backlash, and now we're about to go through it again with this gay marriage fiasco, there's some peculiar psychological disability that we all suffer from. Let me elaborate a bit. We on the left, on the progressive left in this country, are in a bizarre political rut. We get a victory on the court, Brown, Roe, Lawrence, and then we neglect politics. Then we have decades of losses, unsurprisingly, in the political realm that utterly swamp the judicial victory. And then for some weird fetishistic or politically masochistic reason, we do it again. And I don't know when we are going to learn to stop engaging in that incredibly self-destructive pattern of behavior. Just to elaborate on some of the particular political costs, particularly in the abortion context of constitutionalizing this issue. When we constitutionalize an issue, it seems to me, we express, I know I should come up with some other formulation because I don't mean we intend to express, but we send a message out there somehow that we don't trust the political process, and that the political process is profoundly infantile. That what politicians do when they represent people is just sort of channel those constituents' desires and preferences and needs in an infantile way, that constituents have infantile needs and desires, and politicians sort of channel them and take votes and all of that stuff. And that the court, by contrast, reasons in a deliberative and principled way, in a high-minded way, in a morally salutary way, that the court is the one that actually is the institution that actually engages in politics in the highest sense, meaning a group of equals deliberating on difficult questions of shared concern to a political community. And when we do that, the damage to our political process is not trivial. But I can't put this in the form of a question. I want to share with you my sense that it's not only the damage to the political process that's trivial, it's also the damage to that very idea of human rights and human liberty and equality that you and I both care about. If we really care about those things, we've got to make them political issues again, and not legal issues. We've got to make them political. That's why I left out all my praise of Dawn, because I ran out of time. But this woman, when she was head of NARAL, she was the one, I don't know, maybe you had others, she was the one in the abortion rights movement who insisted on this point, that on focusing on legislation, on focusing on laws, on focusing on politics, rather than on focusing on Supreme Court adjudication. So there's a way.
Very short, I agree with you. But I don't think for me it's not an either or. I think we have to do the legislative first of all, the reality is we have Roe. Okay. With all its weaknesses, we sort of have Roe. And I totally agree with you that we need to bring this to the political process. We need to reinforce this through the political process and through the legislative process. I'm simply not willing again, I'm not willing to totally leave this to the tyranny of the majority. I think there are such things I think there are some things legislators don't get to decide in its final form. But I still believe that we should be much more active legislatively. But I'm not waiting for that. I'm not letting women die until that happens.
Yeah, I just want to say, thank you, Robin. But it wasn't just me. It was Frances back in the 80s. I worked on these issues full time, 88 to 93, essentially, and Frances was there, and Kate Michael and so many others. And our big message then was you cannot trust the courts. That was the message of all, so I just think you're not factually correct. Ever since at least the 80s. And I just wasn't involved before then. But my personal experience is we have been trying to make this a political issue and have been working at every level of politics. Today, Planned Parenthood's affiliates, in every state, they like to make sure people understand, 5% of what they do is abortion related, 95% is the common ground kinds of things we're talking about, but they are in the Indiana State Legislature. Betty Kopp from Planned Parenthood, it's just amazing. And it's, as I said, it's not working well. It's a huge problem, and I'd love to see ways for this to work to help. But nobody's been just working in the court.
I understand that, Dawn. But the question is whether or not the existence of this case, this body of law, and this institution is part of what makes it so hard.
I don't see it at all. I think it's helped women, and it continues to help women. I'm with Frances. We wanted to keep, as we work in the political arenas, keep whatever protection we can as long as we can.
I want to give Rick the next word, and then I want to invite the audience to come up to the mics, and we can open
just really quickly, I wouldn't want to be understood, I didn't mean to say that we shouldn't, as a general rule, ever entrench fundamental rights in constitutions. So maybe I differ with Peter on this as well. I think the Constitution does entrench certain fundamental rights, and judges ought to enforce them, and fundamental rights ought not to be left to the whims of political majorities and all that. I guess I'm closer to Peter on thinking that the right to abortion and its content and its limits is so contested, and in fact it's not one that we the people did remove from the political process, in my opinion.
Then I would be the one who say, let's let fundamental rights be subject to the whim of majorities. I'd rather have them be subject to the political process than to the judicial. I do believe there are fundamental rights, and I think that they're the product of politics, and if they're the product of decent democratic politics, all the better.
You're definitely more optimistic about the view of the majority on women.
Right.
Okay, now we have about 25 minutes, and I want to invite people to come up, and we'll do 3 questions each side, and then I'll ask the panelists to respond, and then we'll take the next wave. So we'll start here and then go. Yes.
Hi, my name is Jennifer Brown. I'm a lawyer and at times have been an activist on reproductive rights. I just want to raise a perspective on morality that I haven't heard in 2 days, which is, I guess the short sentence is, what is the morality of preferring and favoring biological happenstance over human decision-making? I don't understand that from a moral perspective. And just to elaborate a bit, the strong messages yesterday about the potential of the fertilized egg and the potential of the human being, we don't rely as humans on biological determinism. We don't live naked in the woods eating nuts and berries. And everything that has allowed us to develop all our human potentials is about not relying on biological determinism. So what's the human moral basis of relying on biology and moments of biological happenstance when it comes to bringing into the world yet another human being and ushering it forward on its growth and development of its potential?
Thank you, Jennifer. Yes, one question here.
For many years, and maybe even still, the Playboy Foundation was one of the largest funders of the NARAL. Since abortion has been legalized, what used to be called pornography has become acceptable. it's become very difficult for young women to refuse sex on a date if she expects to go out with the man again. The economic position of women has declined.
Your question, please.
How can you say that the objectification of the fetus in Roe has lessened the objectification of women in society?
Thank you.
My question is for Peter and Robin and anyone else. And it's, how can you have so much faith in the political process in this country that's broken? We have rich shadow organizations that are paying for the candidates. We have state legislatures that are dysfunctional. We have Fox News that is brainwashing the American people. We heard Dawn call for truth and faithfulness in representation facts, and a large number of the American people believe in that our president was born in Kenya and is a Muslim. How can you have faith in a political process? Peter, you may have been thinking of the UK and Australia, those other countries, but given what we see and we know and the influence of money, how can we have any faith in the political process with an oppositional Republican Party?
Thank you very much. Next question.
My question is directed to Francis. I'm very excited by what you said about the idea of embodied rights and body rights. I love that idea as a woman. This is my body. It's mine. You can't mess with it. It belongs to me. And my question is, I got my body at the moment of conception. It grew in my mother's womb, and I was actually born with a body. And I'm curious as to when and where and how you got your body.
Thank you very much. One question here.
My question is actually to Professor Johnson. You spent a pretty considerable amount of time discussing the tiered scrutiny system that the court tends to use when describing how far the government can go in dealing with fundamental rights. But I'd like you to touch a bit more upon actually what those fundamental rights are, because I don't think that the tiered scrutiny system in and of itself decides what those rights are. And both before Roe and after Roe, there's been two planks that the court has tended to use in describing what fundamental rights are. Number one, that it's rooted in the nation's histories and traditions, and two, that it's fundamental or essential to our scheme of ordered liberty, and those come from two cases in the earlier period. And I was just wondering, number one, do you think that Roe versus Wade, the decision, passes those tests? And two, if you think that those tests, do you think those tests are right or wrong? And then three, what tests would you recommend, and how could you demonstrate that those tests don't give judges unfettered discretion finding fundamental rights? Thank you.
Thank you very much. I want to remind the audience that this is a conference where we're respectfully debating an issue, and the clapping is not, we don't want any clapping. That does not enlighten this debate. We're here to listen, and we're here to enlighten. And the clapping is a political act that is not part of this conference. Next question, and then we'll ask people to respond.
Hi, my question is for Francis, and it is, do you think it would be permissible to kill 1 million people in order to assure bodily integrity or equality in society? And if not, do you think that the moral status of the fetus is therefore a paramount question in this debate, and what's your view on that? That's a little related to the previous question. Thanks.
Okay, now I'll ask the panelists to respond to these 6 questions. Who would like to start? Richard?
I say that the only, all very interesting, the only one I feel really sort of competent to maybe speak to a little bit was the one about the test for fundamental rights, and how is it that we go about identifying the content of the 14th Amendment, right? I mean, I think most people agree, and this isn't just people on the political left, a lot of people on the political right as well, would say, yeah, the 14th Amendment does have some substantive content besides just what's listed in the first 8 amendments of the Bill of Rights. How do you go about identifying that content in a way that doesn't swallow up democracy? It's a hard problem. I don't think there's an easy answer. I tend to agree with the questioner that you do want to look at history and tradition, practices that are deeply rooted in our nation's experience, and so on. If you define it too broadly, I think you undercut democracy. If you define it too narrowly, you might make the mistake of leaving things that ought not to be left to political whims, left to political whims.
I just asked, did I hear you say earlier that Griswold you thought was correct, that there was a fundamental liberty at stake in using contraception?
I think Griswold is plausible.
Okay, I think.
So on the having faith in politics, I don't know anybody with faith in politics these days. The first branch of our government is utterly and profoundly broken. And the first order of business has got to be to repair it. We've got to fix it. There's no shortcut, and you're not going to get a fix out of the Supreme Court. They're part of the problem. They're not part of the solution. At Georgetown, here's just my little contribution to this, we're leading a consortium of law schools in an attempt to create legislative clerkships for smart graduates of law schools rather than judicial clerkships, so that perhaps the legislature can have some of this talent and this idealism and this sort of boundless enthusiasm for law and all that now is bestowed upon the courts. Yeah, it's a bad problem. It's a chicken and egg problem because it's hard to know how to get on top of the problem, obviously, and the court's action and Citizens United has certainly made it a much, much tougher problem. But until and unless we get it fixed, we're not going to have secure fundamental rights and liberties and human rights and all of that. We have got to get the democracy working. And I do believe that the liberal victories of the last 50 years has contributed at least to the brain drain of that has led to the degradation of our democracy, meaning that people are of goodwill and of good instincts are attracted to this process of litigating social issues rather than organizing their communities. On what fundamental rights, just keep in mind, right to own slaves, that was the first substantive due process right. A right to own a gun, now a big one. A right to homeschool, which the court hasn't ruled on. I take it from something you said that you were for it. I think this would be devastating for public education in this country. A right of corporations to buy elections. I mean, these rights go on and on and on. You just better watch out what you wish for. Dawn?
So I essentially want to agree with Professor Garnett, right as I said, I think in Griswold, the fundamental liberty is identical in Griswold as in Roe. That part of the analysis, and I just say for a woman and to some extent for men as well, the ability to not be forced to have, 10, 15 children over the course of one's reproductive lifetime is as fundamental as it gets. So I think it is implicit in the concept of ordered liberty that I've been blessed with 2 wonderful children. I've been so lucky at a time of my choosing, like most, almost 50-year-olds. I've spent decades avoiding pregnancy and a few years trying to get pregnant, and I was able to get pregnant. And that, if the government could prevent me from controlling that, nothing is more central, I think, to women's liberty, and my husband would have been gravely affected as well. So I would say, implicit in the concept of ordered liberty, and I would add equal citizenship for women. That women the concept of equality for women has to include, and that includes political equality, in the working of democracy. So I don't know if we get Peter on board that way, but I do think, if you want women to be equal citizens and participants in our political life, that it does need to be protected from the whims of democratic legislatures.
Rick is asked just for a quick response.
I do, and as you know, Don, I think there are a lot of folks who'd say that Griswold can be right, and the interest that's being protected there and the right that's being vindicated there is dramatically different from the one asserted in Roe. I realize you think it's the same, but I just wanted to make sure I registered that I think they are different.
I think you can totally agree with Griswold and not Roe, but as I said, they're both the right to decide when and whether to have a child, but the government interest is hugely different. And you absolutely can, the government interest in protecting the potentiality of life of the embryo and fetus, that completely distinguishes the two. Peter?
Right. I think in response to what Ruth Macklin asked, I think I really share what Robin said. So I don't think I need to repeat what she said very well as far as I'm concerned. So let me respond to the question about what's the morality of favouring biological happenstance over human decision-making. Obviously none. I guess the way the question is phrased suggests that human decision-making generally is better. and I agree. But I don't really think that answers the questions that we were discussing earlier on, because it's possible that biological happenstance leads to the creation of a being who has rights. I mean, that's the pro-life position. And once that being has rights, whether it exists by choice or by biological happenstance, the view would be that you must not end that life. So that needs to be argued against in some way or another. I suggested one way, there may be others. And I don't think you can simply say, well, human decision-making is better than biological happenstance, and you don't need to go into the other argument.
Well, I was asked a personal question, and I'm going to give a personal answer, but I do want to say that I think that personal answers and our personal experience, while valuable, are not the substance of generalization. I don't want anybody to generalize from what I say, but I'm going to give my answer. I got my body at tremendous price to my mother. That's where I got my body. And my mother paid the price of giving me this body for her entire life. I'm not going to tell you my life story or her life story, but she paid a very profound price for having me. Now, this may, I hope this doesn't offend anybody, but I want to take this one step further. How I think about that now is a way I could not think about that when I was a fetus. But I would, if I could think about that, what I would like to think from the person I am today, I would have felt as a fetus, given my love for her, is that it would have been fine. In fact, it would have been better had she chosen not to have me and to have a happier life. And I would like to think that the I of today, if I could be that when I was in the uterus, would have wanted that in a very deep way for her. So that's my answer to that question. So I say, I don't know if it offends anybody. I mean it in the deepest way, with no flipness associated with, fetuses can't make decisions. But that's it. The second question I was asked was this question about, would I countenance the killing of 1 million people in the service of the bodily autonomy, integrity of others? This is where we divide. We go back to yesterday. I don't think, the answer to that question is no. However, I don't see the relevance of that question to abortion, because I don't believe, and I don't have, I think there's doubt about many things in life, but I don't have much doubt about this, although maybe I could be wrong. I don't believe fetuses are persons. So the question was not, for me, relevant. Or even if not persons, I don't think the value is comparable to the value we normally accord to living human persons.
Dawn's got one quick response, and then we'll have the 4 final questions, and then...
Yeah, I just wanted to apologize to Professor Garnett if he thinks I misrepresented your view in any way, because I did not mean in any way to suggest that I didn't understand you were saying you supported Griswold and not Roe. It's my view, as I said, that the liberty, as describing what I thought the liberty at issue was, and I think it's the same. Okay, thank you.
Okay, we'll start here, and please your name and your question.
Hi, my name is Nick Curry, and I guess my question, when we're considering constitutional questions, I guess we're considering issues that have to do with our identity, our common identity in a pluralistic society. And I was in Iraq 2 weeks ago, and I had some interesting discussions with some people there. And I found that the best justifications and the best arguments that I could make against 9/11 and against recognizing that in a pluralistic society we have profound differences religiously, philosophically, profoundly different ways that we identify our common humanity. And from the perspective of others who think differently and have different perspectives, whether they be philosophical or religious, and how they look at other human beings in that context.
Please?
The question is, basically, in that case, I found the best argument that I could make is basically that these things are wrong because of the intrinsic value of human life. And once I left that argument, my question is, constitutionally, if we lose a respect for that insight and that understanding and don't have a universal understanding of that, how can we make arguments to those who do think in a different way, either philosophically or religiously, concerning issues like this?
Thank you.
Hi, Shivani Radhakrishnan. So I'm wondering, if we grant that, as some people have argued, that questions about abortion are political matters, what guidance does the Constitution give us on whether or not abortion policy should be made by state legislatures versus the federal government?
Thank you.
Okay. Sometimes at a conference like this, you just almost feel the need to stop it. This conference is almost over, and I have felt that on a certain level, the esprit de corps has gone south, and I'm just going to face the room for a minute, because we are at what is the toughest issue of them all, I think, the constitutional right to an abortion, to have open hearts, open mind, and fair-minded words about. And I just want to remind everyone that when we're coming together, that every single person in this room decided to come here knowing that this is what the conference is about. So personally, I want to commend everybody and remind you all that you all came here, even the people who sound the most divided, because there was something about it that drew you here and you wanted to be part of it. And that when President Obama, to circle back, was giving his speech at Notre Dame, which Charlie was inspired by to put this conference on, he talked about, I think he was Father Ted, planning, getting people on the Civil Rights Commission together because he realized that everyone liked fishing. So he went out and rented a boat that night for everyone to fish together. So I just want to inspire everybody to remember the conversations that you've had and remember that there's a lot of good that's come of it. I'm done. Thank you.
I think
sorry, it wasn't a question, but I felt like things had gone so far descending at this point. Goodbye.
Hi, Laura Chasen, Public Conversations Project. What I observe about this panel is that what has been a duality for the rest of the conference has become a triangle. We've got the concern for the fetus, the concern for the woman, and now the concern for the democracy. And I wish we had another day to have that triangular conversation. And what I want to ask you is whether you think, I think that when you bring democracy in, what I want to ask is whether you see a possibility of convergence among pretty much all of us who are here if we look ahead to the next 5 years. I think it's possible that the situation for women and fetuses and children and everybody is going to get much worse as the budget cuts come in. And whether we could form a coalition to make sure that the most vulnerable are not the ones who get cut is my question.
Back to the panel, because time is with us.
I'm interested in pursuing this issue of significant religious differences. And one comment has to do with, Peter said that it was dogma, that we were going to reject dogma, but at its best, religions present good arguments. And I think one of the interesting things about Catholic moral theology is it's presented a very powerful argument based on natural law, which is, by the way, itself a religious claim. It's not a claim in Judaism, and therefore I want to ask, when there's even a fundamental difference about something that looks like a nice Hellenistic concept, but is really put forward as a part of a sincere religious tradition, how do we then take account both politically or constitutionally of significant religious difference at the basic level of language, especially for minorities such as Jews, Muslims, Hindus, and Buddhists, who simply don't share that same concept of natural law as normative?
Thank you.
My name is Mary Daly. I'm from the University of Notre Dame. I was wondering if the panelists could speak to the relationship with regards to women's rights, if they could speak to the relationship between a mother's woman's rights and a daughter's woman's rights. Thank you.
Final question.
Hi, I'm Mariana Garcia. I'm from Jire, Mexico City, and I have a question. If both movements implies the defense of one or more fundamental rights, then I remit to the first question of this panel. Should it be a constitutional question?
I didn't hear that.
Should it be a constitutional question, you ask?
Should it be a constitutional question?
Should it be a constitutional right?
Should abortion be a constitutional right?
Right.
Okay, thank you. Okay, who wants to start? Okay, okay. Rob, okay.
So, with the exception perhaps of human rights, I do think that rights traditions generally tend to become deeply identitarian in a nationalistic way, and that is one of their dangers. State legislatures versus federal legislators, I would have this crazy dream-like response to that if Congress one day passes under the Section 5 of the 14th Amendment a law, right, protecting women in all sorts of ways because of all of these various fundamental rights and liberties, but that Congress does it. Short of that, that's not going to happen. Again, my own preference is that this be done via legislation. The protection of rights, be done via legislation. On possibilities of convergence on political points of agreement coming out of this conference, that's the reason I came here. We've all spoken on why we came here. I was not anticipating really shared values. I was anticipating people finding political points of convergence on common projects coming from different systems of values. And so I completely endorse this notion of somehow fashioning from these 2 days a sort of action agenda of what we can do over the next few years to protect the most vulnerable families, mothers, children, and fathers as we go forward. That seems to me to be the point of most common convergence, the way to bring down abortion rates, but the way to bring down unwanted pregnancies really is to address the poverty that motivates the vast majority of the decisions to abort. I view that in part as a way of repoliticizing this issue in a healthy way. That is part of the political process, and that's part of the political process that we've lost over the last X number of years, X number of decades, I think, since this became something other than a straightforward, not simple, but straightforward political issue.
Dawn?
So I'd agree with Professor West that I'd love to see us finding, whatever word you use, a list of policies that we can agree will help promote healthy families and work at the state and federal level. And I think it would help to do that if, to the extent the courts do not continue to protect the right to choose up to the point of fetal viability. If Congress would establish, some floor protection, I think that getting good things done in the Indiana legislature and legislatures all across the country is, being held hostage to abortion restrictions, and would like to work on an affirmative agenda that all of us in this room, there are many things all of us in this room could agree to do both at the state and federal level that would be for the good of women and families. Peter?
Yes, on Laura Zoroff's point, it's true that historically the natural law tradition has been associated with the Roman Catholic Church, but it's certainly not only Roman Catholics who've regarded themselves as following natural law, and it's also true that it is a tradition that attempts to put reasoned arguments. Now, I happen to think that it's fallacious. I think that it's not just fallacious in particular points about abortion, but I think that it's a fallacy to assume that what is in our nature is what we ought to do. So there's a kind of a more fundamental fallacy that if we had a few hours we could discuss with some of the other people around. Would be a very interesting discussion. But I do accept it as not making religious arguments. Whereas if we're talking about a Jewish tradition or an Islamic tradition, I mean, they also have, obviously, reasons and arguments within those traditions among the various wise people who wrote in that tradition. But more typically, people will say, well, it says in the Quran, or it says in Leviticus, or it says in the Talmud, and this is where I take my inspiration from. And to me, that's just not an argument. I mean, these are texts that we can look at to see whether we find wisdom and good arguments in them, but they're not things that I want to give more authority than many other texts that are not treated or respected in the same way by the people of these religions. So that's really, to me, the difference in the nature of argument. So on the constitutional right issue, again, I think this has been said, I don't want abortion to be a constitutional right. I want to persuade people that it's not wrong to take the life of a fetus in the overwhelming majority of cases when women do that through an abortion, and that laws against abortion do more harm than good. Now, maybe I'm naive to think that it's possible to persuade many Americans of that. In that sense, perhaps I'm just optimistic about the role that eventually reason and discussion and argument can play in the world.
Since I have played the role of Princess of Darkness in this debate, I will have nothing more to say.
Just a quick one. The point that Mary Daly raised at the end made me think that, one of the difficulties that some people have identified with, con law talk, I'm thinking of Mary Ann Glendon, is that we get so locked into kind of this, and you talked about this too, Rob, rights talk, clashing individual rights. It makes us think about who we are in our relations to each other in perhaps distorted ways. I mean, for those of us who are pro-life, it's inescapable that you have women who are, of course, of ultimate, and not to say nothing of equal, but of ultimate human dignity. And the same thing is true, I believe, of unborn children. And that does complicate legal questions, to say the least. And it makes me inclined to think that the political arena is better for trying to negotiate this balance between rights and interests and values and commitments that are all pretty important.
Okay, now, do I take it that those are the last points that the panelists wanted to make? And then I hope you'll join me in thanking the panelists for a very enlightening debate. We're going to move very quickly into closing. We promised you that we would end at 5:30, and we might be 2 minutes over, but we'll see what we can do. All of the organizers are going to come up on the stage. Maybe you could take a microphone. Pleasure. You could take a microphone from one of these pocket microphones. Here's what we're going to do for 5 minutes. This is a short 5-minute closing, and we want you to think about something for a minute or two. Because the last thing that's going to happen is that you're going to talk to each other. And what we would like you to do is think about somebody close to you so you don't have to go running around the room and wasting a lot of time, that you don't know, that you may disagree with. And we're going to ask you in a minute or two to share with them one thing you learned or were surprised by at this conference. And we're going to do that as part of, I'm okay, my thing is working. We're going to do this as part of our closing. So we'd like to ask, where's Charlie?
Right here.
Come on forward, I'm too far back.
Did everyone hear that? Is everyone, there's a lot of talking going on, so I think it's tough to maybe hear what was just said. You did not hear. Okay. So what we're going to ask you to do at this point, and we're going to need your attention in order to do this, is after each of us is going to take a minute or two to talk about something that struck us or surprised us as a result of this conference. We're going to ask each of you to turn to someone that you don't know in your vicinity and share that with them and have them share that with you. And take as much time as you'd like to do that after we're done. You could take just a couple of minutes. You could sit in here for 15 minutes, a half hour. You could exchange email addresses, phone numbers, whatever you'd like to do. As we said at the very onset of this conference, we hope that you get to know people that are different than you and build these buds of friendship that we hope grow over time. So each of us is going to get it started. Jen will start, we'll go right down the line, and then we'll turn it over to you, and that will be the end.
Great, thank you. I'm a very slow thinker. I actually tend to think better in silence and in nature. But here we go. In the beginning, when we were planning this conference, Charlie scheduled or wanted to schedule a lot of time for drinks. And social time for interaction for very good reasons, not for drinking reasons, but in that they often allow or facilitate bonding and spaces where people feel comfortable to open up. And I would say that we probably didn't need the drinks, that with enough time together in one room and sitting on hard chairs, that did it. Because at the end, we all seem to start telling it like it is to some extent, right? The barriers fell a little bit.